Hey guys. Oh, bless you. Sorry, baby sneezing. Um, this is going to wrap up our discussion for the divorce chapter in your family law text. That's chapter 5. Um, we had gotten up through talking about alternative dispute resolution in divorces and also about the role of parental coordinators. Um, we're looking now at jurisdictional issues. So, as we know, a court has to have the right subject matter jurisdiction. So, for divorce, that's going to be a family court. If there's property involved in another state, then we may be using another state's law to deal with that piece of property. And we also have to have personal jurisdiction over the defendant. In divorce cases, first we're looking at what is the residency requirement for plaintiffs. Um, as long as a plaintiff is domiciled in a state, then they can bring a divorce action in that state. Um, your textbook lists out a lot of the factors that can help determine domicile, but in a nutshell, it's the place where you permanently live. So even if you take trips to other places or you spend part of the year somewhere else, it's a place that you think of as your permanent home, the place you intend to go back to when you stop traveling around. So there's some tips, things like places which state is your driver's license issued in, where do you have a voter registration, where you pay income taxes, where your residence may be, where your family lives, where you work, things like that. If the plaintiff is domiciled in the state, again, they can bring a divorce action within that state. Now we have to have personal jurisdiction over a defendant as well. And 4 basic ways that you establish personal jurisdiction over a defendant in a divorce case. First, presence. So if you can serve the defendant while they're in that state that the plaintiff wants to file in. They don't have to be living there. They can be there on a visit or vacation, so long as they're served inside the state. Domicile. So obviously if they're domiciled in the same state as the plaintiff, then they can be have a divorce action brought against them there. Consent. So the defendant can consent to personal jurisdiction, even if it wouldn't otherwise apply to them. And finally, what we call a minimum contacts test. So this is basically looking at how many connections or relationships does the defendant have with the state. Do they do business there? Do they have property there? Was an action of theirs that gave rise to the claim, did it happen there? Most importantly for us in a divorce context, if there was a marital residence maintained within the state, then the defendant satisfies that personal jurisdiction requirement. What else? Moving on now to grounds for divorce. We've already talked about the fact that there are 2 basic frameworks for obtaining a divorce. The first is through a no-fault based ground. That is where parties are not looking to assign blame. They're simply looking to end the marriage. Usually we describe that as either irreconcilable differences or an irretrievable breakdown of the marriage. Okay. So often that no-fault grounds requires a certain length of time that the parties live separate and apart. We've talked about the fact that South Carolina requires those parties to live separately and apart for a minimum of 12 continuous months. Other states can set their minimum length of time as they wish. What else? So that's no fault based grounds. For fault based grounds, we recognize some basic general ones. The first being adultery, which is just having sex with someone outside of the marriage. Secondly, desertion or abandonment. That's where one party leaves the other party. Sometimes called a divorce of bed and board. That is, they've left the marital residence. They're not staying there. They're not providing support. Okay. Third ground for fault-based divorce is cruelty. Often this encompasses physical, emotional, or mental abuse. Next, we have habitual drunkenness or drug abuse. That is recognized as a grounds for the divorce as well. And again, it needs to rise to that level that it is negatively impacting the marriage. So the fact that someone has a few drinks every once in a while is not going to satisfy a fault-based ground of habitual drunkenness. It needs to be something that rises to the level of alcoholism. Okay. What else? Finally, a lot of states recognize fault-based ground for criminal convictions or criminal incarceration. States vary as to how serious of a crime or what types of crimes that those convictions can stand as a divorce ground for. There is a case in your text, Flotzer versus Morris Flotzer, out of the state of New York in 2004, that looks at a cruelty fault-based divorce. This one, the plaintiff in the case is actually the husband, and the defendant in the case is the wife, and he has alleged cruelty grounds against her for harassment, amongst other things. What else? Need to take a look at defenses to divorce actions. That is defendants' ways to object to or to challenge a divorce. A couple of the basic defenses that are available normally in civil actions: lack of subject matter jurisdiction or personal jurisdiction, that it's the wrong venue or forum non-convenience, okay? That the defendant wasn't served properly, okay? Lack of service, failure of the plaintiff to state a claim. That is basically that the plaintiff is alleged a ground of divorce that doesn't exist in the state that the plaintiff's filing in, okay? Or that the matter is res judicata, which just means that the marriage or the divorce has already been handled by another state or by another court in another state. And finally, invalidity of the marriage. Okay, in order to obtain a divorce, you have to have a valid marriage. Couple special defenses apply if a fault-based ground is asserted by the plaintiff. That is cruelty, adultery, drunkenness or drug abuse, incarceration. So if you have one of those fault-based grounds, then you have some special defenses that are also available. The first one is condonation, which basically just means forgiveness and going on with it. Provocation, okay, which is where the plaintiff provoked the conduct that they're complaining about. The next one's recrimination, and that is where the defendant alleges that the plaintiff has also committed that marital wrong. Okay. Connivance is another ground or defense to a fault-based ground divorce. It involves when the defendant alleges that a plaintiff has consented to or participated in the act that the plaintiff is complaining about. Okay. Finally, collusion. That is when the parties are found by the court to basically be working together. If you're asking yourself, why would parties who want a divorce be working together? It might be in order to obtain some benefits. So perhaps one party would be eligible for a greater tax benefit or for a greater disability benefit, something of that nature, if they were single rather than divorced. So they're basically colluding in this fraud of a divorce when they do intend to stay together. So that's collusion. But remember those last 5 grounds: condonation, provocation, recrimination, connivance, and collusion only apply when you have a fault-based ground that's been asserted. The rest of the chapter deals with mostly the process of going and preparing for trial in a divorce case. Those steps are just like they are in any other civil case. So a complaint is filed by the plaintiff. The defendant has a limited amount of time, 30 days, in which to answer the complaint, where they admit and deny the allegations in the complaint. Additional motions might be filed in a divorce case before trial. Motions for temporary support, motions preventing one party from taking kids out of state, motions that might request orders to protect property from one spouse or the other trying to dispose of it or otherwise spend it. So all of those normal steps apply, but you might have some of those motions that would be appropriate for a divorce case filed. Another type of motion that might be filed if the divorce involves minor children, you can have an appointment for a guardian ad litem, a GAL, guardian ad litem. That person's role is to represent the interests of minor children in the case. And then make a recommendation on custody, visitation issues to the judge. The judge is then free to accept or to reject the guardian ad litem's recommendations. They are just recommendations, but the court generally puts a lot of emphasis or puts a lot of stock into recommendations of guardian ad litems. What else? You'll have the discovery process, just like you would in any other civil trial. Quiet. So you'll be requesting information from the other side. You might be doing document requests for documents that relate to property that might be owned or to 401k plans, things like that. The trial, as any other civil trial, is going to be weighed the burden of proof based on the preponderance of the evidence. So the plaintiff or the defendant needs to prove their side in that 51% range. Okay, more likely than not is the standard there. Once the court issues a final judgment, only then does the divorce become legal or finalized. Okay. I think that is it for that chapter. So we will touch on just a couple of these points when we meet on Wednesday, but that is our wrap up for the divorce section.